Thank you to the University of Vienna and the Ludwig Boltzmann Institute for inviting me. It's of course lovely to be at my first in-person international conference in quite some time, but it's also very nice to be participating in this hybrid event. So welcome to my co-panelist. Also, let's hope that this is the way forward for future conferences. It's being done so well here. Let us also hope that it's the way forward to always see a panel on this important topic at conferences such as this, because as I am going to discuss, the role of domestic courts in delivering justice for conflict-related sexual violence is critical indeed. The absence of an international or a hybrid court that was capable of exercising jurisdiction over violations of international criminal and humanitarian law in the Syrian conflict has led victims, legal representatives, NGOs, and indeed national investigators and prosecutors in third states to seek creative avenues of legal redress, notably exploiting the availability of extraterritorial and universal jurisdiction in a number of states. By the start of this year, over 545 proceedings had been conducted or commenced at the domestic level in at least 41 states against individuals involved in the Syrian conflict. That's the last time I tried to count, would need updating now. The majority of these proceedings were against suspected Islamic State members, many of whom did not in fact travel to Syria, but were charged with terrorism offenses related to being a member of IS, disseminating IS propaganda, recruiting for the group, providing material support, or having the intent to travel to Syria to participate in the conflict. So although the sheer volume of that response shows that the criminal justice systems have responded foremost to the need to counter the violent extremist threat by IS and other terrorist groups, at home or when their foreign terrorist fighters seek to return home. Notwithstanding this, nearly 6 proceedings against suspected members of Islamic State, the Syrian military and security agencies, and members of other armed groups have been triggered by states exercising their extraterritorial or universal jurisdiction, including, in some instances, for conflict and atrocity-related sexual violence. I would like to briefly focus on some of the landmark proceedings that we have seen to date in relation to sexual violence, that is, the progress, before I turn to some of the challenges. Only some 20 or so proceedings have been launched overall against suspected members of the Syrian regime's military and security agencies on suspicion of a range of crimes from torture, war crimes, crimes against humanity, and other charges. Some cases have resulted from investigations that were initiated by domestic investigators and prosecutors, while others have been triggered by a flurry of NGO complaints. Occasionally, family members of Syrian disappeared persons have filed complaints in third states, seeking an investigation based on passive nationality. But to date, most of those cases have met with little success because they relied on the dual nationality of the relatives rather than the direct victim. For example, a case filed in Spain by the dual national sister of a Syrian citizen who was arbitrarily detained, tortured, and executed in a detention center in Damascus was dismissed by the Spanish Supreme Court, holding that Spanish courts lack jurisdiction over the crimes. The decision was upheld on appeal to the Constitutional Court, which ruled that a prima facie violation of the sister's rights had not been established. Overall, these proceedings worldwide have resulted in very few arrests of Syrian government actors, and only 2 individuals have been convicted so far, both relatively low-level perpetrators, and neither of those defendants were charged with sexual violence. However, a few of the cases have reached the point of arrest and charging of an accused include explicit allegations of sexual violence. All of those cases have been in Germany and are presently at the pre-trial or trial stage. In the well-known case of Anwar R., which was discussed by several of my fellow co-speakers yesterday, the accused, who is a former member of Syrian General Intelligence, was not originally charged with offenses of a sexual nature. But at trial, the court heard testimony from both male and female victim witnesses about such conduct. And upon a motion of the Nebenkläger, that is the legal representative of the victims, the crime against humanity of sexual violence was added to the indictment in March of this year. And that case is ongoing. In the case of Ala M, a medical doctor who worked in Syrian military intelligence in Homs, the accused faces multiple counts of crimes against humanity and grievous bodily harm for acts of killing, torture, and deprivation of liberty. He was arrested in June 2020, and the federal prosecutor later added charges of a sexual nature last December, which relate to the deprivation of reproductive capacity in relation to an alleged incident in which the accused doused the genitals of a 14 or 15-year-old boy with alcohol and set him on fire. A subsequent second expansion of the charges in July of this year added an additional such instance, as well as some other incidents of attacks on the genitalia of detainees. In relation to sexual violence or other criminality by members of Islamic State, again, Germany alone has brought charges against both its own and foreign nationals in a number of cases. They relate mainly to the IS slave trade in women and children. Again, as we heard yesterday, a husband and wife of Iraqi and German nationality, respectively, went on trial separately in Germany in 2019 and 2020 for their alleged roles in the death of the 5-year-old daughter of a Yazidi woman enslaved in their house in Fallujah. The key witness in the case, the Yazidi mother, who is also a participating victim, or more correctly, co-plaintiff in the proceedings in both cases, testified that Taha al-Jay purchased her as a Sabiya, a female slave, and prior to this, she had been enslaved by other IS members who raped her in Syria. Taha al-Jay is the first person to face genocide charges for having a role in the IS slave trade. Meanwhile, his wife, Jennifer W., is charged with war crimes, among other charges, and is alleged to have been a member of IS's female police unit that enforced the group's interpretation of Sharia law against women, the Al-Hizba. As the former federal prosecutor mentioned yesterday, Germany has charged several other female suspected IS members with crimes against humanity, war crimes, and trafficking in relation to holding Yazidi women and children as slaves in their homes in Syria. On the 16th of June last, the Higher Regional Court in Düsseldorf convicted Sarah O., a now 23-year-old German and Algerian citizen, under juvenile criminal procedure for offenses committed in Syria, including membership in IS and crimes against humanity related to the enslavement of 7 female Yazidi captives. She was sentenced as a minor to 6.5 years imprisonment. She was found guilty of aiding and abetting rape, enslavement, and religious and gender-based persecution as crimes against humanity, among other offenses. That conviction represents the first conviction of an IS member worldwide for sexual violence. The verdict is the third conviction of an IS member for enslavement, the first 2 cases being also against German women, Omema A and Nurten J. So far, we have seen almost no discussion of the fact that Sarah O was an underage girl accused of aiding and abetting rape committed by her husband, but perhaps when the judgment is available. In a series of other proceedings against female German citizens, charges of, among other things, violation of their duty of care in relation to children whom they brought to Syria, bearing weapons whilst in IS territory, and the war crime of appropriation of property have also been charged. In these instances, there was no evidence of involvement in IS slavery or other crimes. So to date, only one other case related to sexual violence perpetrated by IS in Syria has been brought under the principle of universal jurisdiction, again in Germany. However, in that case, Akram A., the charge of rape as a war crime and all other charges were dropped after the suspect, and the suspect was released after further investigation, which established that an alternative course of events was possible. So it's clear, Germany is the leading jurisdiction in the prosecution of both male and female suspected IS members and members of Syrian military and security apparatuses who were involved in sexual and gender-based violence and crimes against children. However, it is worth mentioning that corporate criminal and civil complaints have also been filed in relation to IS crimes in other jurisdictions. We already had mentioned this morning in the panel with Mateusz Petic of the Lafarge-Holcim case in France, which has just seen the annulment of the part of the indictment that dealt with crimes against humanity overturned and returned to the investigation chamber for further consideration. And what is interesting about that is that a group of Yazidi victims have sought to join the case as parties civile, alleging that some of the complicity in crimes against humanity by Lafarge took place in 2014 when the crimes against them were committed in Syria. So this may become an aspect of that case in the future. In Australia, a victim's compensation claim was brought on behalf of a group of 5 Yazidi women who were enslaved and subjected to sexual violence, among other violations, by an Australian IS member. An initial request was rejected by the New South Wales Civil and Administrative Tribunal in 2019, citing lack of jurisdiction on the basis that the scheme has no clear extraterritorial effect, but that is under appeal. So, despite the fact that it's very clear from this brief rundown that only the initial steps have been taken towards accountability for sexual violence in the Syrian conflict to date, I believe it is still not too early for us to already reflect on some of the core challenges around bringing forward these cases in practice. I should pause and mention here that I am, of course, only speaking now about the realm of domestic prosecutions. The recourse to the International Court of Justice for an advisory opinion, or to the International Criminal Court for spillover jurisdiction, or even the idea of establishing an internationalized court based on the pooled jurisdiction of states are a little bit beyond the scope today, and definitely in the interests of time, I won't go into details on those. As we can see, though, these domestic cases, while meaningful, provide only fragments of justice in answer to an astounding array and volume of sexual violence in the Syria and Iraq conflicts that have touched the lives of thousands of men, women, and children. These gaps stem primarily from the lack of availability of suspects in states that are willing and able to exercise jurisdiction over ICHL violations, and not just for terrorism alone. In addition to not addressing the lion's share of criminality, this has resulted in a notable pattern of focusing on returning IS wives and direct low-level perpetrators, for the most part, rather than those who are alleged to have orchestrated entire systems of slavery and civilian detention designed to inflict sexual violence and an array of other crimes on individuals. This really begs the question for me, would we benefit from a common strategy to prosecuting conflict-related sexual violence in Syria and the Iraqi conflicts through extraterritorial and universal jurisdiction? Might such an approach serve to maximize opportunities for cooperation and coordination that could help bring more perpetrators to justice, but also help prevent anomalies and disparities in charging, sentencing, and even engagement with victims and affected communities? Apart from the obvious impunity gap, a key challenge for prosecutors is obtaining sufficient evidence, which is something I actually don't think we have touched on very much so far in the conference. Particularly linkage evidence, which we know is critical for building individual criminal responsibility cases. Here, partnerships and information sharing can be key. As you have just heard, NGOs and victim complaints have been absolutely instrumental in triggering several cases or resulting in the addition of sexual violence charges to existing cases. The Commission for International Justice and Accountability, CIJA, where I serve, is also an NGO, but our role is not strategic litigation, but rather evidence gathering. We have been investigating sexual violence and other violations of ICHL inside Syria since 2014, but we also look at the period prior to that. The role of CIJA is not to replace the efforts of national investigators and prosecutors, but rather to secure vulnerable evidence and make it available to them. Hence, we have built working relationships with dozens of law enforcement bodies in 14 states, I believe, as well as international bodies such as the IIIM, UNITAD, the OPCW, the Eurojust mechanisms, and a number of partner NGOs who are pursuing different kinds of universal jurisdiction complaints. We have also prepared numerous case files detailing evidence of sexual violence perpetrated by both the Syrian regime and IS. And in several cases to go to trial to date, CIJA has offered assistance to the authorities during the investigation and the trial, including provision of documentary evidence and expert testimony. For example, in the Anwar R case discussed by several of the other speakers. Increasingly, this assistance extends to inquiries into sexual and gender-based violence by domestic prosecutors. In 2019-2020 alone, CIJA answered nearly 24 requests for assistance from states related just to the IS slave trade. Meanwhile, a number of the pending universal jurisdiction complaints filed by NGOs include allegations of sexual and gender-based violence, and it simply remains to be seen if opportunities for arrest and trial of accused persons arise in relation to these complaints. Lack of familiarity of domestic judiciaries with complex and highly sensitive cases of sexual and gender-based violence amounting to genocide and crimes against humanity is also a challenge. This in turn can be compounded by the different cultural contexts in which the crimes took place. In some cases that I will not mention by name as they remain sub judice, there have been clear examples of re-traumatization and stigmatization of survivors in the courtroom. In still other cases, we do not know how survivors who testified fared on the stand because the proceedings were closed to the public for the protection of the defendant. As mentioned by Professor Stephanie Bock yesterday, the accessibility of proceedings is of course also a challenge, even when they are open, particularly during the pandemic. Distance and the difficulty to travel is not the only issue. It is not commonplace to see delayed streaming broadcasts, simultaneous translation, transcripts, and publication of the indictments, motions, pleadings, decisions, and verdicts. We do need to think about ensuring that when justice is done, it is seen to be done. Yet we also need to think about witness protection amid an ongoing conflict. A very important historical record is being established, and some of the most hidden crimes are being brought to light in these cases, piecemeal as it is. But in the case of Syria, supreme care needs to be taken, as these cases are adjudicating an ongoing conflict in which witnesses and their loved ones require ongoing protection from armed actors. Notwithstanding these challenges, the undeniable case study that is Germany's effort might offer lessons and good practices that could be adapted to other domestic systems. This, in fact, does not only mean Europe or even the West, but could also imply some states of the region, notably the Republic of Iraq, which has many suspected IS members in detention who may bear responsibility for ICHL violations. Iraq faces, of course, a number of legal challenges with respect to potentially prosecuting IS criminality. It lacks a legal framework that criminalizes war crimes, crimes against humanity, and genocide. But it does have some offenses such as slavery and trafficking in both its penal code and lex specialis. However, its judicial culture leans towards application of the terrorist paradigm and the consequent application of the death penalty, rather than seeking legal qualifications that could fully encapsulate the harms experienced by the victims, including the sexual and gendered harms. Also, neither application of international law in criminal proceedings nor cumulative charging is widely accepted or practiced, though neither is prohibited by any legal provision. The recent successes in Europe, and Germany in particular, might offer material for a rich and meaningful engagement with Iraq's justice system on addressing impunity at home. There is much to be gained, I believe, in encouraging exchanges between investigators and prosecutors working across jurisdictions about how to make the best use of available evidence and find appropriate legal characterizations, especially to deliver justice for sexual crimes. I'll leave my remarks there and I look forward to the Q&A. Thank you.